A number of clients ask us what the best option is for them in their particular circumstances, and on a number of occasions, private FDRs, being private financial dispute resolution hearings, can be a good way forward. There was one such case where proceedings had been issued before the court because we just weren't able to agree an appropriate way forward at the early stages. The parties had to comply with a number of court directions. It was taking quite a while for those directions to be complied with, and the parties were understanding and feeling the delay that was being encountered in dealing with this before the traditional court. We got to the stage whereby we were then going to consider proposals, which happens at a financial dispute resolution hearing. And we suggested to both parties that perhaps the way forward is not to deal with this before the traditional court, but to do it on a private basis. And what that means is they both agree to fund a private judge who sits and adjudicates, or in this case, and just gives an opinion on their case. The benefit of that, despite the fact that you're paying for them, is that they dedicate time to the case. They read all the papers. You're not on a list with 6 or 7 other cases. And they understand the issues and therefore can give a better opinion and a better indication on the issues in the case. This one was quite complex because we had, again, assets in different jurisdictions. There were pensions and trusts that we needed to deal with. So we all agreed that we would list it for a 2-day private FDR. And we sat before a judge who had read all the papers, who had asked a number of questions prior to us attending, so that we were able to answer issues and make sure that we were making the best use of the time when we were all sitting before them for 2 days. As a result of that, we managed to reach a consensual conclusion. We were able the following day to sit down, put the terms together in an order, and file that ultimately at court. And that avoided what was likely to be a 4 or 5 day trial that could have arisen if we had been involved in the court process still.